application and appeal in the matter of Dr. MN and NHS Foundation Trust L.
Now, let me say at the start, I'm aware that concern has been expressed over live streaming, and we have maintained the position that, in accordance with the principle of open justice, there should be live streaming. I ought to reiterate what is anyway obvious, that we should all make sure that we don't mention names. It isn't, I think, a case where there's any need at all to mention names. The questions raised are points of law where really the identities of individuals are entirely material. I would also have thought, though, you're welcome to tell me otherwise, that it's not a case where a client needs to be sitting close to the advocates, because it's not a matter on which the client is really going to be able to add anything. So by all means seek to persuade us otherwise, but we have discussed it again, and at the moment maintain the position that the principle of open justice means that there ought to be live streaming.
We've made adjustments to accommodate all the concerns that have been expressed in correspondence.
Yes.
And so we're happy to proceed presently. And in relation to names, we've agreed, my learned friend and I, Mr Sutton and I have agreed, I represent the trust, who's the appellant, and his client is the doctor.
Yes.
That won't prohibit stray references or mistaken or stumbling references, but hopefully we can avoid that. Somebody can be on with a red flag to say stop or something along those lines. But as your lordship rightly observes, these are hard-edged issues of law that don't really require personal biography or identity.
No. Mr Sutton, are you living with that?
Content with the course you've described.
Thank you very much.
Can I deal first of all with appearances? I appear on behalf of the trust, along with my learned friend Mr Jack Mitchell. For the doctor, my learned friend Mark Sutton, King's Counsel, leads Miss Nicola Newey. In relation to the anonymity point, we've already addressed your lordships in relation to that. In relation to nomenclature, just so we're all clear, I'll use the term medical director rather than chief medical officer, which is the term which has changed. And likewise in relation to director of human resources, whom I put the acronym down of HRD. That's human resources director. In fact, that's changed now to chief people officer, but that doesn't matter for these purposes, as long as we know what we're dealing with. In terms of the identification of who's doing what, I'm going to deal with the principal grounds and the cross appeal stroke respondent's notice. We need to pick up on that in terms of whether your lordships are going to deal with that as a discrete initial issue, or whether we're just going to get on with it and deal with it in submissions as we go along.
I think it's best that we just deal with things as we go along.
Yes, I'm grateful. I'm dealing with those 2 points. My learned friend Mr Mitchell is going to deal with the appeal in relation to costs. Your lordship will see that there's an issue that we raise in relation to sidestepping, and we're going to sidestep that. I'm not going to take that before your lordships. We don't. It's academic. It's over to. We needn't deal with it now at this level. In terms of the identification of the materials that you and your colleagues have, my lord, your lordship has got the skeleton argument on behalf of the appellant, as well as the additional supplementary skeleton argument dealing with the provision to build your lordship granted leave to deal with. You should have a learned friend's substantive skeleton argument. I put in a speaking note in order to try and help, rather than walk the court through material provisions. What I've sought to do is to summarise them and, as it were, corral them into various helpful, I hope, parts. which I'll take your lordships to in due course, if I may. But that also deals with, in terms of roles, that also deals with, your lordships will see on page 6, the relevant roles of officers who aren't either case investigators or case managers. The medical director, the human resources director, the DBM, which is the designated board member, that's page 7, paragraph 22. And then I also deal with independent external assistance that could be required, is required. And that's first of all through PPA, again, changing the nomenclature, was NCAS, now PPA, it's the same body, just a different name. And then in relation to external medical assistance, I there identify the 3 stages, as it were, when that can be procured if it's necessary. In terms of that document as well, can I just clarify this point in relation to framework for procedure? So back to page 1, paragraph 2. Insofar as foundation trusts are concerned, the status or the institution of a foundation trust was introduced in, I think, in April 2004, and this trust was awarded the foundation trust in 2008. We say no more about that in detail, so as not to give any identifying details in it. Can I then just deal with the structure of my submissions, how I intend to address the court, if I may? I hope to keep it refined to 7 matters. First is by way of a summary. The second is an analysis of the facts and how we got here. And by that I mean how we got here, what the dispute was between the parties. Third is dealing with the judge's reasons and reasoning. 4 will deal with legal principles. And it's right to say there's a significant amount of agreement in relation to what the relevant legal principles are. But what I'd like to do in my submissions is take the court to 3 or 4 cases that deal with when a collective agreement gets incorporated into an individual contract of employment, and when that clause will become apt for incorporation. And we'll see, and we'll go into more detail, but that very often is in relation to highly important issues such as pay or severance pay or the like. We'll go into that by way of key for the other cases. 5th, I'm going to deal with why we say the judge erred in law. And that splits into 3 analyses. Looking at the contract of employment, that's in relation to the incorporation point. Then I'll deal with the E27 policy, which is the policy that we're concerned with here. And then, out of respect to the learned judge, I'll go through his analysis and pick up where we say it is, with respect, wrong. Then I'll deal at 6 with the cross appeal or the respondent's notice, but I'll deal with that extremely lightly because learned friends yet to get permission in relation to that. But we say in 4 pages. It's wrong as a cross appeal, it's misconceived as a respondent's notice, but I can deal with that very quickly. And then at 7, my learned friend Mr Mitchell will deal with the issue in relation to costs. As I say, the sidestep issue has or is no longer a live issue before this court. Can I then just deal with my submissions by way of summary in relation to the matters that I'm dealing with, not the cross appeal? The issue in this case is about who can occupy the role of case manager in an MHPS investigation under the Trust's local procedure, and specifically when a consultant or higher grade is involved, whether that person, in other words, the case manager, has to be medical director. The finding of the judge was that it has to be and must be the medical director unless there are certain established exceptions. That's the implied term issue that he made reference to and we'll come to in our submissions. The judge found in three ways for the claimant. First, that the E27 policy was incorporated. And we were troubled by that because he appeared to proceed on the basis that there was a concession that it was incorporated, and it never was. And that's absolutely clear from the list of issues. But in any event, we say the method of incorporation under clause 17.1 is opaque, if not unclear. And we say in those circumstances that immediate starting off point was wrong by the judge. Next, in any event, we say in relation to aptness and meaning and effect, the two tend to overlap, and they do indeed in the judgment. We say this, that when one looks at the key clause, which is clause 1.6, both in terms of where it sits, both in terms of where it comes from, MHPS, the reference framework, and we'll look at that. We say that this is a classic case of generalised guidance, and it's only that. It provides for a procedure in which the employer ought to have the flexibility to decide who occupies which roles, so long as the person occupying the role is a suitable person. And we say it cannot be and should not be interpreted so that there is a, as it were, an iron cast obligation, regardless of the circumstances, that in the case of a consultant or above, it ought to be the medical director. We say that simply isn't right. But even if it is right, we say the meaning of it, as the judge found, cannot be right. Because we say a reference to the medical director does not preclude that medical director acting through others. In other words, delegating his or her role to another in appropriate circumstances. And we say that the clear language of E27 does not prohibit delegation, and if it did, it would require the clearest indication that is absent in that policy and indeed in NHS. We say that this, our analysis cannot be rescued on behalf of the respondent, either by the cross appeal or the respondent's notice. And in any event, we because of the nature of this case and the public importance, we say in relation to the issue of who should be the medical director and when, this is a matter which the court ought to pronounce on in any event. So can I then, in light of that, just deal with my second part of the of my submission, which is the facts, which I largely take from the judgment. And I know that this is a case on an issue of law, but what informs the issues is, of course, the factual matrix between the parties and how this matter arose. Can I just take a paragraph 5? So if we go to the core bundle, and I can bring your lordships to the judgment itself, which, as I say, I take largely the facts from, but not exclusively. So that's page 39. Paragraphs 4 and 5. The factual matrix relates to supervised observational visits made to Hospital X by Lucy Letby in 2017. The background to that was that Letby worked at the Countess of Chester, as we know, and worked alongside the doctor in this case on the neonatal ward, the doctor being a senior registrar at the time. And on that ward, we know that there were proven crimes committed by Letby up to July of 2016. She was then removed from clinical responsibilities in the July or August of 2016 and was in effect put on an admin role from that time. Her dealings with the claimant, her relationship with the claimant was professional and personal. They were friends. And again, I'm not straying into any facts which may form the basis of any investigation. I'm just putting this as neutrally as I possibly can. And that relationship endured when the doctor left and joined Hospital X in September 2016. What then happened was that in the December of 2016, the doctor in this case arranged for observational visits to Hospital Trust X by Letby. The paperwork, it was sponsored or facilitated by the doctor. The paperwork was filled out from both ends, including an honorary contract and permission from the employer, which was the Countess of Chester. They remained Letby's employer. And thereafter, Letby undertook observational visits to Hospital Trust X in 2017. The precise number is not clear, it was probably 4 or 5. One of the visits was to the paediatric intensive care unit where neonatal babies are treated. Those visits, which were supervised and described as observational visits, were terminated by the Countess of Chester Hospital in May 2017, when the police announced that they were opening up an investigation into the deaths of 8 babies. Letby was arrested in July 18. The doctor was employed by the trust from the 1st of July 18. The criminal investigation commenced, in which the doctor became a witness, was interviewed and provided statements on a number of occasions, and he became a witness at the criminal trial and was granted lifelong anonymity by Mr Justice Sheldon on the 7th of October 2022, and that's in the supplementary from page 199. We know that Letby was convicted of 7 murders and 6 attempted murders on the 18th of August 2023, when the jury's entire verdict was delivered, which then, of course, produced a significant, if not huge, public and press reaction. On the 22nd of August, so within days of that coming out, on the 22nd of August, the doctor identified himself to the Deputy Chief Medical Officer and identified himself as a witness in the criminal trial. He was known at that stage, he was ciphered as Dr. A. This caused a meeting to be had between the medical director, that's Mr. Z, as ciphered in the case, and the chief nursing officer on the 25th of August of 2023. And if I could just take your lordships briefly to this point in the supplementary bundle. So if I can just take your lordships to page 6, which is a note stroke half completed letter from the medical director, Mr. Z, in relation to the meeting on the 25th of August. I'll take you to page 6. And invite the lordships to read that. I'll come to the emphasis, which is on page 7 in the top paragraph.
Just to be clear, do we really need any of this?
No. Well, my lord, you don't in the sense of adjudicate on your decision, but in terms of some of the issues that arose in relation to the roles of, for instance, the medical director, was he compromised? Was he therefore a suitable person to continue with it? This is what we're looking at. This is why I've taken you to it.
And is that really something we're going to be deciding?
No, you're not deciding that, but in terms of the legal issue as to whether a medical director should and should not act, or can and cannot act, it is not factual. There are lots of circumstances in which that person may choose to act or may not choose to act.
And I can see that you can argue that without reference to these particular facts. I mean, if you really think we need to look at this stuff, then let's look at it. But I am conscious of the requirement to maintain anonymity, and the more we look at particular materials, the more that's put at risk.
The long and short of this, my lord, is that the meeting left the medical director happy that there was nothing to see insofar as the let-be visits. In other words, he was reassured that the doctor didn't have any knowledge or suspicion of any of the concerns over let-be when she was invited in. That's it. And then again, this is in the bundle on the 29th of August. And this is, so your lordship can just see this and see if your lordship gets anything from it. Page 17, on the 29th of August, there was a complaint from a parent, a mother, of one of the let-be victims, which is child N. Which was complaining essentially, that's page 17, the bottom email, essentially complaining that there had been breaches of the patient confidentiality of her child. The child N was the subject of an attempted murder charge, which there were 3 counts, one of which was established, and let-be was found guilty in relation to that child. And that's what, as the judge rightly observes, we say, that's what changes this from what appears to be a meeting in which reassurance is given to a meeting in which that reassurance potentially disappears. That there appears to have been a far greater hinterland of relationship between let-be and the doctor. That just frames the concerns of the trust. And those concerns are then reflected in the TORs, or the terms of reference, which your lordships have. And can I take your lordship to that very briefly? It's at the supplementary bundle at page 330. There are 2. They are virtually identical, save that the first one doesn't make a reference to MHPS, and the second one does.
Sorry, which page are you on?
Okay, we start at 330.
Oh, I haven't got a 330.
In the supplemental?
My supplemental stops at 329, so something has gone awry.
Well, we can have this matter corrected, but can I just explain this? We can go back to the, in fact, to the judgment, because at paragraph 12 this is dealt with expressly. So can I take you back to the judgment? Core bundle, page 43, paragraph 12. And we can perhaps, if your lordship needs to see it, we can resolve the mystery.
Yeah.
And this, at this stage, was a non-MHPS investigation, albeit it was, as it were, following the principles of MHPS. And it was put on the basis that this was a matter that went to the trust's trust and confidence in the doctor, rather than any issue of conduct or performance. That gets compromised down the line, but that's how it starts. By compromise down the line, it's accepted that the trust applied MHPS from the 15th of March, but it isn't accepted, of course, MHPS was followed. And so the your lordships will have in paragraph 12, page 43 of the judgment.
Yep.
The brief to the external investigators was to look into, amongst other things, the doctor's prior knowledge of concerns about let-be and the events of the Countess of Chester in 2015 and 2016. You'll also see, my lord, second bulletproof down is the facilitating, in other words, how did she come into Trust X, and the third is in relation to baby N issue, and in more detail at 13, and the doctor's prior knowledge, court will see what it's there to read in terms of the factual landscape that the investigator is being asked to traverse and come back with a report on. In terms of the chronology, your lordships will see that this was in the January of 2024. There was a meeting on the 23rd of January 2024 with the doctor, with the then case manager, Ms Y, and Dr Zev as well, the medical director. However, matters were significantly delayed by a number of issues. The first was the Thirlwall inquiry, Lady Justice Thirlwall. That was commenced in the October, so a lot of this overlaps with Lady Justice Thirlwall's inquiry. That was commenced in October, 19th of October 2023, and that, in fact, asked for evidence from the doctor on 2 occasions, and that was not completed by the doctor until September 2024. And they asked the trust specifically not to interview the doctor as per the investigation, not to interview the doctor until the Rule 9, as it's known, processes were completed, and of course the trust agreed with that. So that knocked it back until September, and arising out of that as well, Miss Y was asked by the claimant's claimant's lawyers to, as it were, to get green light for the investigation from the Thirlwall inquiry. The Lordship will see this in the judgment. She did that, was given it, and then the inquiry was concerned about matters of the visits themselves, and therefore she had to provide a Rule 9 written statement. And your Lordships will recall from the judgment, this formed the basis of ground 4, which was dismissed and it was not appealed, which was that somehow she overstepped the mark in responding or dealing with the Thirlwall inquiry. And then on the 7th of October, her evidence was read to the Thirlwall inquiry, and on the 7th of October, the very same day, the doctor in this case gave evidence and was asked questions about, amongst other things, his interactions with Letby and the like, and indeed his knowledge of matters in relation to consent. There was also a challenge that was made as to whether the trust were right in not applying MHPS. That was resolved by the 15th of March, whereby the trust agreed to apply and to follow MHPS. So if I can take your Lordship to the supplementary bundle very briefly, page 39. Just give you the references. That's the letter where the trust identifies what it had been doing, which was consonant with following MHPS, but then it goes on to say we are following MHPS. There's no issue on this. It's page 39 through to 41. That's then followed up on the 12th of April 2024 with a further letter to DWF. I'm not taking your Lordships to it. There's a thicket of correspondence dealing with issues that arose, and I put it as neutrally as that. And that was further referenced by Miss Y on page 46 in the letter of the 12th of April. And in particular under MHPS, your Lordships will see in Roman numeral 1. The medical director will assume the nominal role of case manager, will however delegate responsibility for this to myself. So MHS is being applied, the medical director delegates the responsibility to Ms. Y. And then over the page, the formal evidence of that is on page 48. Same day, as the letter that we've looked at. I beg your pardon, 2 days later. I invite your lordships to look at that. It's very short. Part of the reason why he's not acting as the medical director is that he was retaining the pastoral support role in respect of the. And we can go back to it a little bit later, and we'll come to this a little bit later on, further on. That arose out of the meeting on the 23rd of January when the doctor was told of the concerns in the investigations. A further delaying feature was the fact that the doctor fell ill, and in terms of updating your lordships in relation to progress, the investigation continues, and the doctor, in fact, has been interviewed by the case investigator.
Sorry, by the
Case investigator, who is Mr. A, I think. It is Mr. A. And this, in terms of the challenge, culminates in a letter of claim, page 54. Again, take this extremely briefly, which is some 12 pages in length, which, as it were, throws up a whole series of challenges to the trust. That's page 54 of the supplemental. And in particular, on page 11, the report has the, as it were, 7 plates that are being made in the letter of claim. Which I needn't take your lordships to, has a substantive response to. In the meantime, as was compelled under the E27 procedure, and by MHS being applied, I mean the Trust C27 procedure, the body with statutory oversight of these matters, both in terms of advice and assistance, PPA, were consulted, if I can take your lordships to page 194, were consulted on the 31st of July 24 and the 7th of August 24, and offered their view in relation to the case discussion.
Sorry, where are you getting?
194 is the letter from PPA which records the 2 phone calls on the 31st of July and the 7th of August.
194 in my bundle
Of the supplemental.
is the supplemental bundle is part of a witness statement.
Seem to have a problem
yes,
with your
and in mine.
well,
But it probably doesn't matter.
it
for our
probably
purposes.
doesn't matter. I'm as it were setting the frame for
Yes.
where this goes, because we have the direct evidence from PPA at the trial, which I will take your lordships to, albeit briefly.
What was the date of the letter you were looking for?
The date of the letter is the 6th of September 2024. Page, is,
I think it's page 94.
is that 94? Well, that's
That
entirely my
that would-
fault.
that would
my
make-
page numbering
means
is,
that there's less of a mystery.
has gone awry.
Yes.
Thank you to Mr Mitchell for pointing out my incompetence. But mine is marked 194195 for some unknown reason. The point in terms of the advice, the first paragraph 94 is the detail. In terms of the advice, can I just invite your lordships to page 95, the penultimate paragraph in some respects. Sorry, the paragraph above that, which frames, as it were, the complaints that were being taken to PPA.
Sorry.
You have responded to
Yes,
the MPS.
So you'd like us to read from there
That,
to the end of the page, or
yes, please. And then over the page.
Sorry, I'm being a bit slow. Who is this addressed to?
This is addressed to Miss Y,
And she is
the
the
case
case
manager.
manager to whom it has been delegated under the...
Yes.
Yes.
Yes. And this is from Mr Wilkinson, who, as I say, was a witness, albeit he wasn't called at the trial. So,
sorry, I'll just
my apologies.
What do you want us to read? The last 3 paragraphs on 95.
And then over the page to the final two, sorry, the top two.
Yes, Mark, perhaps the top 3.
The top 3, my learned friend wants. So.
Yeah. Yes.
I'm grateful. And the position was then, in terms of chronology, your lordships will have seen that there was an independent external investigator called Verita who were identified as the investigators. By February, a new investigator an internal investigator was appointed by the case manager. And that's
And
Mr.
this is a case investigator.
This is a case investigator, Mr A, who also was called to give evidence but was not cross-examined.
So, sorry, we saw that Verita, an external body, was originally asked to investigate, but
Yes.
they were replaced by Mr. A when?
In February, 13th of February, and that's, I think we'd even go to it. I think your lordship gets the note on that from page 1, 2, 3. In fact, it's expressly in that letter on 13th of February to the doctors, lawyers, page 1, 2, 3 of the supplemental. And that's then reflected in the document that you don't seem to have, I don't think, which is the new TORs, which
No, I have.
you have it. I'm grateful.
Yes, I have them as well. I think they were added very recently.
Well, having it printed and they'll be brought from my lord,
Thank you very much.
Justice Newey, in the fullness of time. And then in the March of 2025, the
So
Trust
25.
in the March of this year, the trust was served with the proceedings in this case, and the court has that. That's the 21st of March. The court has that in the core bundle at page 88 to 113. And just for the sake of completeness, you've seen we've got the letter of claim in June 24, we've got the proceedings in the March of 2024, with the case manager remaining the same throughout. And you've got in the core bundle at page 88 the particulars of claim, and in particular, your lordships have at page 110 at paragraph 82 the particulars of breach, which are eightfold, A through to H. And for the purposes of this appeal, point and issue is at B. And if I may, in just finishing the second part of my subs in relation to the facts and how we came to get here, can I just focus on, as at the March of 2025, what the position was on the ground. The case manager was and remained Miss Y. She was delegated that once MHPS was accepted in the April. We've seen that. We know what the focus of the investigation was, which in this case is the knowledge of the doctor in relation to the concerns about Letby at the time. And some relevant points I want to make in this part are these. As your lordship will see, none of those concerns in relation to the TORs have anything to do with medical skill or the exercise of medical skill. It's about a personal, factual issue, we say. In terms of the role and the actions of Miss Y, she maintained her position until the judgment in this case and was then removed and replaced by Mr Z, the medical director. Can I just deal briefly with Miss Y? Miss Y, it's never been said, is unsuited or unsuitable to act as case manager, other than the fact that she's not the medical director. She's a member of the board and has been for a significant period of time. Her title is Director of Corporate Affairs. Her selection, both pre and post MHPS being applied, is perfectly, we say, encapsulated in the judgment. If I can take your lordships to that when the judge deals with the issue of the witness evidence of the trial. So we're back in the court conduct. Paragraph 37 deals with the oral evidence and the non-oral evidence. In other words, what the witness statements were. I'll take this to paragraph 37 quickly. So there's evidence from the doctor was heard, as well as Miss Y and Mr W, who is the current CEO, and then statements of others, including Mr Wilkinson, that Mr A and Mr Z were provided but not challenged. And in terms of the selection of Miss Y, this is dealt with in paragraph 41 of the judgment. Can I just invite your lordship to read that paragraph?
Yes. Yes.
And the position we say is highlighted by that. She's eminently suitable, eminently competent. There is no suggestion that anything she has done, other than the third wall communication, which I'll deal with very, very briefly, other than the third wall communication, there's no suggestion that anything she has done is wrong or inappropriate. So she set the TORs, she's appointed a case investigator, albeit through the medical director, which is a condition, provision we'll look at when we have a look at my speaking note very briefly. She set, as it were, the homework for the case investigator, and she's dealt with matters as they have gone along by way of the extensive challenge on behalf of the doctor. And as I say, I'm not going to go into that. There has been a multitude of challenges that have come through that correspondence, and no concern, we say, can ever be raised in relation to her, how she has dealt with matters. And in particular, we say that throws into sharp relief or sharp light the point what we say is the outcome in this case, which is that a perfectly competent and perfectly suitable case manager cannot continue simply because she's not the medical director. And we say that as a proposition of common sense in an ordinary domestic employment relationship is borderline absurd. But we'll put that a little better in terms of how we put it in terms of our submissions. Aligned to that, I just want to address the court, is why Mr Z didn't regard himself as suitable to be case manager at the time. And we brushed past this briefly in relation to the 14th of April. But we get it more clearly in Mr Z's witness statement. Now, I take a deep breath here to make sure if we're all there. Supplemental bundle, page 190. And just in terms of just backfilling some facts, your Lordship will see in paragraph 4, I'll wait for your Lordship to get there. Paragraph 4 deals with the publicity issue, which I raised, albeit very briefly. If your Lordship go to paragraph 4, in particular, and I'm not going into detail, in particular, paragraph 4, significant national newspaper interest. Paragraph 5 is in terms of his responsibility in respect of the doctor, the RO and ultimate line manager. And then 7 deals with the meeting, which we've looked at very briefly and avoided going into the content.
Can you just explain to me what responsible officer is? It's obviously a specific term.
I'll have a go. Doctors have to be, as it were, MOT'd every revalidation over a certain cycle, and also have to be, as it were, man-marked by a responsible officer who makes sure that they are competent and fit to do their job. So it's, as it were, another layer of regulation outside of the GMC, outside of the regulator. I hope I haven't mangled this, but that's my understanding of it. So that's what a responsible officer is. So that is the person who, as it were, has eyes on the doctor for the purposes of assessing that they're fit and competent.
That's their clinical competence.
Yeah. But not just their clinical competence. Other issues can come into it, but principally in relation to clinical competence.
Thank you.
And then we deal with he deals with the issue in relation to how this was dealt with. And specifically, he deals with the selection of case manager in terms of reference. He deals with this in paragraph 13. Again, the point that we've already looked and paragraph, so we needn't spend any time, but paragraph 16 deals expressly with the position which comes out of the 23rd of January 23 meeting, reflected in the 14th of April 24 email, which I've taken you to, which is he's taking on a pastoral role. Can I take your lordships to those? For the Lord Justice Newey,
Thank you very much.
Pages, my apologies, I'm not sure what's happened, but
It may well be something that's happened internally here.
well, I'm prepared to blame Mr Mitchell in any event for that. So.
Thank you very much.
And that explains why he felt that the roles were properly divided. And then he goes on further to explain that paragraph 20 onwards, and I invite your lordships to this if I may, paragraph 20 to 26, as to why he wasn't or acting as the medical man.
Yes.
Great. That explains why, not least in relation to oversight, he wasn't the medical director, wasn't appropriate for it. Just before I go to move on to my third point about the judge's reasoning and findings, can I just finish this off in relation to Miss Y? And I did allude a little bit earlier to the point that there was a challenge in relation to the way that she conducted relations in respect to the Thirlwall inquiry. I can take your lordships to the finding on that, and we needn't go to that in any greater detail. That's issue 4, which was brought as an implied term of trust and confidence. That's page 73 of the court bundle, paragraph 121. In particular 122 on this. Miss Y, having been effectively told by the doctor's lawyers that she should go to the Thirlwall inquiry and only get their approval to proceed if they give it, did precisely that. Got the approval, then found herself responding to a Rule 9, which I've dealt with. But in any event, there is no criticism that is either established or of any substance in relation to the way that she has discharged her functions. Can I then deal with my third point, which is the judge's reasoning and findings? And as I'm going to, as it were, overlap that with my dealing with his points in our legal submissions, I can take this extremely quickly, if I may. The first point is in relation to whether E27 as a policy was incorporated. That's dealt with 93 to 94. The next issue is in relation to meaning and aptness, and the two are treated interchangeably, I think, as I've already indicated. That's dealt with at paragraph 103, so that's page 69. And at 106 in terms of considerations of aptness which influence the judge. And of course this is an issue of law and therefore an issue for you. I needn't spend at least any great time highlighting that at this stage. Can I then deal with relevant legal principles before I come on to our submissions, if I may? This is my fourth submission. As I indicated at my opening, I want to take your lordships to cases where the relevant terms do give rise to enforceable individual obligations, and have a look at some of those cases for the purposes of by way of illustration and by way of example, if I may. There seems to be very little between us in terms of the applicable legal principles. We in our skeleton cite from Mrs Justice Simler's decision in Chakrabarti, which seems to adopt or sit on the shoulders, if that's the correct expression, of Mr Justice Andrew Smith. And we deal with this in paragraph 11 of our 10 and 11 of our skeleton. I just give you the reference there. And I'll come on to what those principles are in a minute. But in terms of the framework for acting, in terms of what is the court involved with here, if I can take your lordships to the general principles and the judgment in al-Mishlab, which I think is in a separate, is a second authorities bundle for your lordships. This should be at tab 13. And you'll see in any event that there are shades of what's being said here that crosses over into the other cases. And it's a dicta and guidance which is given specifically in Chakrabarti. Can I take your lordship to the al-Mishlab? Sorry, I minced that. The case of al-Mishlab. It's at page 374 of the authorities bundle. It's tab 13, and this is the decision of Mr Justice Green in the High Court, dealing with an application made the day before a hearing was to take place, an internal hearing was to take place. And it's an extempore judgment, but we say that that doesn't inhibit it from expressing common sense. We needn't go to the facts of the case, although there are shades of what things which arise in this case. In that case, the doctor was facing a panel for, amongst other things, trust and confidence, and was complaining that that was out with the MHPS. If I can take your lordships to D, analysis and conclusion at 178, and invite your lordships to paragraph 16 to 21, which we say encapsulate what the court should be doing and what the role of it is.
Meaning you would like us to read 16 to 21?
Yes, please.
Yes.
Great. Just two points to draw from that very quickly, if I may. Paragraph 19, public interest in allowing internal processes to run their course. And court should be slow to interfere if disputed issues can be sought out, resolved within the framework of internal procedures. Except that's not on all fours with this case, but the spirit is right, particularly in relation to you're complaining about somebody in respect of whom you can't complain about. And paragraph 21 in Chakrabarti, which we cite, and I'll go back to it in a moment if I may, that these procedures, and that's E27 here, shouldn't be treated as if it were a statute, and shouldn't be read as if it were a statute. It should be read flexibly and in a common sense way. If I may then just take the court back to my skeleton where I would get the 5 principles that Mr Justice Sheldon takes from various cases, including the case of Singh. There are 5 points in relation to whether a provision is incorporated and in fact apt to be incorporated. First is the importance of the provision to the working relationship, and
Do you want us to look at your skeleton?
yeah, I can certainly give you the reference. It's page 3, paragraph 11. We highlight there what Mr Justice Sheldon says. I'm just giving you the broken down principles that emerge from page
And so
355.
you're really taking what you're saying from the highlighted text.
Yes.
Yep.
And I'm just, as it were, distilling it.
Yes.
So it's the importance of, and this leans on the learning that has come before it, which you can go back to when you're dealing with collective agreements, procedures being agreed and then being adopted by the employer. Query, is that of legal effect? And if it is it apt to be incorporated? And this is what we're looking at here in terms of, is it apt to be incorporated? And the principles which help. I'm not suggesting they're a straitjacket, they simply help. And they are importance of the provision to the working relationship. And that's going to lead me on to the 4/5 cases I want to deal with very briefly as to when that arises. The relationship of the provision to contractual arrangements between the parties, the level of detail prescribed by the provision, and the need for the courts to avoid being involved in micromanagement, the certainty of provision and the workability of the provision. As I say, those are not, that's not a straitjacket. It's helpful, useful guidance. And the next point is in terms of interpretation, which, can I take you to my skeleton, which expressly cites from Chakrabarti in paragraph 116, which has its distillation in what I've taken you to in El Mishlab at paragraph 21. And I've again highlighted the relevant parts there, which we can say.
Sorry, where are we looking at now?
My skeleton,
Which paragraph?
paragraph 12.
Right, thank you.
So we've done 11, which is the 5 propositions. 12 is the interpretive approach. Particularly, that goes back to the point about the hierarchical character of the relationship and allowing the employer to exercise his power as employer through procedures.
You referred to 5 propositions. I'm sorry, I'm being a bit slow. Where do we find the 5 propositions? That's in paragraph 11. Isn't it?
That's in paragraph 11 highlighted, where Mr Justice similar references Hussain,
Yes.
and relevant, including account, that account
Can
is
you
to be
just tell me
taken.
what the 5 are? There's the importance of the working relationship, level of detail, certainty of the provision, whether it would be workable.
Avoiding micromanagement.
That's a separate one, is it?
Yeah. we say.
Thank you.
Although, but these overlap because you can have a.
I understand that, but it was just your reference to 5. Thank you very much.
Can I then just go to those cases that I'd like your lordships to look at briefly in terms of the importance of the provision? Because our point here, which will come into our factual submissions, our point here is that whilst this is an important role, being a case manager, its role does not have the impact on the employment relationship so as to engage the principles we're going to be having a look at now, and that's why I'm going to take you to, first of all, can I just take you not chronologically, I'm going to take you to Keeley, which is behind tab 3. Page 31. This is a redundancy case in which enhanced terms were identified in a staff handbook. Your lordships can get this from the headnote. In fact, instead of me reading it out, can I just invite your lordships very briefly to the facts? This is an employee handbook in which a whole series of benefits and rights were contained in a section, one of which was in relation to redundancy. And in particular, this is the 3rd paragraph down, provisions for compensation, in other words, enhanced redundancy payments to be made in the event of a redundancy. So in other words, pay, albeit severance in relation to the termination of employment, in a handbook, which of course would be of vital importance and vital interest to the employee. And Mr. Keeley, the finding was that the handbook was incorporated into the contract of employment, and in relation to the aptness of the term, the High Court judge found that it wasn't apt to be incorporated on a number of grounds. Mr. Keeley appealed. I'm interested in the Court of Appeal decision. If I can take the lordships to page 32. High Court, the Court of Appeal held. Can I just invite the lordship to read the headnote then?
Yes.
That's a case in which clear language was used of entitlement, which provided for a valuable economic benefit. And in those circumstances, it was plainly apt to be a term of contract. And in particular, the 2 points that I would stress is, first of all, that in that case it's put as high as it could be, which was that the individual was told that they would be subject to or entitled to the benefit. And also, if I can take your lordships to the specific reasoning of paragraph 34 to 36, or 34 and 35 will do.
Would you like us to read those?
Yes, you've read the distillation, but can I just flag it at least? It emphasises the point in clear terms that the importance of the provision to the overall bargain is a key consideration.
Yes, I see. Let's just read it. Yes.
The next case I'd like to take the court to is the case of Sparks, which is at tab 15. It's another handbook case, page 391. It's in the second volume of authorities. This was a Part 8 claim, in other words, not a witness action trial, about whether a handbook which provided for incorporation into a contract of employment and for aptness, whether that specific clause was in fact enforceable by the employee. And if I can just take Lord Justice McCool's decision at 393, the relevant provision is set out there, which was a provision in relation to a sick leave provision, in respect of which trigger points or certain consequences would flow if the threshold in that provision was met. And that sat within, there was a confused bundle of policies, but that sat within, I can take your lordship to page 395, paragraph 9, under the employment document. That sat within, first of all, a contract of employment, a paragraph 9, which provided at 1.2 the department handbooks. In other words, the handbook that contained the provision. It says it's the intention of the recognised trade unions of the Crown that all the provisions of the departmental staff handbook, which apply to you and are apt for incorporation, should be incorporated into your contract of employment. And the issue of concern to the staff was that should only be, as it were, triggered. In other words, the consequences should flow only if its strict terms were met. And Mr Justice Globe was the trial judge in relation to that, and he summarised this in paragraph 11. Can I just take your lordships to that?
So you'd like us to read paragraph 11?
Just paragraph 11, which summarises the arguments, but gets why this provision was so important,
Yep.
why it was being litigated about, and in particular between E and F. And in particular, my lord, E and F, where Mr Justice Globe, the trial judge, set out why this is a provision of importance. The potential consequences of the procedures were serious, capable of leading to formal processes that could have resulted in written warnings and dismissal. I asked you to look at that part in particular because there's treatment of the case of Wandsworth, which is again another framework case, in other words, handbook case. That's dealt with specifically by Lord Justice McComb. It's not in your bundle. In paragraph 14, this is a case which falls the other side of the line to Spark. So if I can take your lordship, invite your lordship to read paragraph 14.
Yes.
And then paragraph 31, which is sidelined in any event, as to the court's determination and the conclusions that these were matters of importance to the employment relationship, and therefore this was not simply guidance.
We better just read that.
Yes, I'd be grateful.
What do you want us to read?
31, my lord, page 403. The sideline mark to 35.
It seems to me that what Lord Justice Dyson had asked during the course of the hearing in Keeley,
Yes,
and is recorded in a number of judgments, including paragraph 31 here,
yes.
may be of some importance. And the proposition which it seems to lead to is if the provisions had been set out in the same terms in a formal contractual document, could it seriously have been argued as a matter of construction that it was not apt for a contractual term?
Absolutely. We accept that. And indeed, that's something that the judge picks up on. Says if this was in the contract, we'll come to that. We say that's not getting the right end of the stick, we say, because you're not looking at its context, and you're not looking where it arises, and you're not looking at its proper meaning, we say. But we'll come to that. So, in other words, at 31 onwards, there's the distinction between guidance, which is Wandsworth, as opposed to a hard-edged formal contractual document, which, as Lord Justice Singh says, if that's in your contract of employment, why wouldn't it be enforceable? And the same applies in Keeley. If that was in the contract of employment, where this comes from, Lord Justice Dyson's observation, there wouldn't be an argument. Likewise, in this case, if the relevant paragraph was in the contract of employment, there wouldn't be an argument because it has serious impacts, has serious effects in relation to the employment relationship, or potentially it does.
And when you say this case, you mean
Spark.
you mean Sparks. You don't
Yes.
mean our case.
I don't mean our case. I mean Sparks. I'm in the authorities.
Yes.
It's Sparks. Yes.
Yes.
Sparks goes that side of the line because this could lead to a process in which you could be ultimately dismissed. That's its importance.
But is this question of if it was set out in the contract, would it be regarded as a term of the contract? Is this a question of the content of the obligation? Or is it a question of the language Because it looks as if what Lord Justice Dyson's talking about is the language of the
Probably both.
probably
We
both.
say yes, because we say even if it's in there, its meaning still has to be discerned. That's what we say in this case. If you drop the medical director will act as case manager into the contract of employment here, it doesn't mean that that's a cast iron contractual right which cannot be abrogated. That you will have the case manager being the medical director. So it's both, my lord, if I've understood the question correctly.
Thank you.
And just to give another example, which if I can take you back to the case of cabage, which is a case that the respondents have put in, but this, I suggest, neatly also highlights the point that I've just been making. So if I can take your lordships to page 18, it's behind tab 2. This is the case in which a council employee is dismissed, quite an old-fashioned case in the sense that he was dismissed for timekeeping. He had a right of appeal inside the council to a panel of councillors, which prescribed that there should be 3 councillors on the appeal. And in fact, when the appeal commenced and completed, in fact, only 2 councillors sat on the appeal, and the appeal was dismissed. He brought his claim to an employment tribunal, industrial tribunal as it was, and the industrial tribunal found that this didn't render the dismissal, the procedural breach, if I can put it as loosely as that, didn't render the dismissal unfair. EAT set that aside and substituted a finding of unfair dismissal. The Court of Appeal set aside the finding of unfair dismissal, but upheld the point that the breach of the procedure is a relevant matter for the purposes of reasonableness under the relevant statute that deals with employment. But the reason why I raise this with the court is that there was an argument in that case whether there was a contractual entitlement by way of the council's procedures, whether there was a contractual entitlement to have a 3-person panel, and that takes it up. That's taken up at page 22. It's an old-fashioned law report, so we have to go with the side markings at C.
Sorry, which page?
That's page 22, my lord.
Thank you.
The paragraph reading Mr Cabage.
Mr Cabage. And this sets up, as it were, the issue in relation to the entitlement to have a 3-person panel. And the argument in that case was that whether that was an entitlement that he enjoyed as a matter of contract. Although this was not an injunction case, wasn't a case in which proceedings had been brought other than in the employment tribunal.
And then we're going forward to page 24, are we?
We are, my lord. Just above the sidelining, starting at C, which was the council's argument before the Court of Appeal, before Lord Justice Morit, on the issue of contract. And the encapsulation is in H in terms of Lord Justice Morit's views.
Yes.
And this isn't side marked, but if I could take your lordships to page 28 of that judgment. And in particular at D and D through to G, which is the argument, albeit relating to what an appeal tribunal can do when it finds there's an error of law, whether it can substitute a finding of unfair dismissal itself. But the words I'd invite you to look at are those I've identified.
Sorry,
That's at D. I accept many of the submissions. And the
you'd
next
like us to
paragraph,
read D to G.
a lawyer is told. That's
Yes.
taking the point at a slightly different angle, albeit in an unfair dismissal context, but it's still the point, which is particularly in relation to contractual procedures, that those contractual procedures which regulate important steps, and here it was an appeal, ought to be have full weight accorded to them, albeit in this case it translated itself into a finding of unfair dismissal because it was a procedural impropriety. But I say that because not just because the respondents have raised this as a case, but I say it helps the court in terms of understanding what level of seriousness that this operates on. And here was a dismissal. And the final case, because I don't have to deal with Wandsworth, the final case I wanted to take your lordships to was the Supreme Court in Union of Shop Distributors and Allied Workers, USDOR, and Tesco's stores. So that's a second bundle, tab 21, and page 503. And I say it probably suffices just to read the head note and the summary. But this is a case in which I think the Lord Justice Newey was present in the Court of Appeal. This was a case about Tesco's inducing employees to move to a new site, and in return for which Tesco's promised to provide retained pay, which was an enhanced pay, which they said effectively was for life. Brutally short summary of it. And the question was whether that, first of all, was a part of the contract of employment. The answer was yes, it was. Second was, did Tesco's act in breach of it? Well, what Tesco's purported to do was give notice to terminate the contract, as they could do under the contract of employment, give notice to terminate the contract of employment, and thereby end that right. And the Supreme Court, it was argued all the way through, and the Supreme Court said that that would be subject to an implied right that you cannot give notice to terminate. You cannot give notice to terminate if that has the effect or the aim of destroying the principal right, which is the right to retain pay as long as you remain employed. So it's quite an unusual case.
It would always have that effect. Was it not the implied term they couldn't do it with the aim of taking away?
Yes, I said the aim and effect.
I thought you said aim or effect.
Oh, aim and effect. My apologies. Strike the or. That's what it is about. Now, I simply provide that to the court in order to show the level at which, again, in relation to pay, that the courts will be concerned with, and the, as it were, the importance of that organ to the employees.
And is there a particular passage we should be looking at?
But my lord, it's a lengthy passage. There are 4 judgments,
Yeah.
and so I don't invite you to dive in. There are some side marked by the respondents, so if I want you to go to them, he'll take you to them. But I take it on a more general level, which shows that just at what level do the courts intervene for the purposes of the point, which is the importance of the provision. Anything to do with pay, anything to do with remuneration, the courts, understandably, are far more interested. Anything to do with dismissal, they are. And anything that could lead to dismissal, they are. Those are the cases that I've taken you to. Anything to do with framework or guidance, they likely won't. That's where the Wandsworth case, which I've taken your lordships to. If I can move then to my point 5, my submission, which is why we say the judge was wrong to find what he did. Can I start this with a reference to some of the contractual documentation? By that I mean the contract of employment, which your lordships have in the code bundle at page 133. It's not actually, unless I've missed it, cited by Mr Justice Sheldon in his judgment. And aside from the usual provisions that one would suggest, page 139, paragraph 17.1 is the route through which the doctor was suggesting that the employer's E27 procedure was incorporated. That's in paragraph 17.1, which is most of these contracts are standard statutory derived terms, as we'll see in a moment in relation to termination. And this 17.1 is a common one, which if you read all the MHPS cases, is a term that's in every doctor's contract and has been interpreted in various ways. And so, as it were, the first issue about incorporation can only come through 17.1, which makes a reference to the matter will be resolved through our disciplinary or capability procedures, which will be consistent with MHPS, subject to appeal arrangements set out in those procedures. So that's the first point. That we say that doesn't incorporate D27, and it can't. We say, just to be absolutely clear, we don't say that you can't derive certain provisions from, for instance, E27. Just putting it generally. We say you're not prohibited. That can apply in certain cases, and in the case of Burn, which my Lord Justice Singh was a part of the court, that was a case about correspondence relating to the case, in which the employer in that case accepted it was a contractual provision, but there was no argument of what it meant. And Mr Z, in part, makes a reference to that, which I'll take you back to in due course. So
sorry, but what's your punchline on the words which will be consistent with the MHPS?
This is, the matter will be resolved through our disciplinary or capability procedures. This is general aspirational language, which says that we will have regard to our adopted procedure. It is not incorporating that procedure, which the judge, the learned judge, thought we had conceded and was.
Well, irrespective of whether you conceded it, what we have to decide is what is its meaning and effect.
Absolutely.
Now, I think your argument is that it's certainly not express incorporation. Is that right?
Yes.
But you also dispute that it's implied incorporation.
As a whole, as the whole document, yes, We do. We don't accept that it's impliedly incorporated, and that is we accept that there are elements of it that might be incorporated, but as a whole, we do not accept it. It's not picked up and dropped into the
So-
employment relationship.
Just to understand that, where elements are incorporated, how are they incorporated?
They're incorporated by reference to the employer acting on and operating the procedure.
Well, we've got the contract here,
Yes.
so how are those elements incorporated by this contract?
Through a process of implication, we say. So there may be there may be some provision. So we'll look at exclusion, for instance. We would say that is a fundamental part of the relationship. If you're going to either exclude or restrict somebody, you would interfere with the working relationship. That is a point of importance to the relationship, and that might, in those circumstances, and has been found in other cases, to be incorporated.
So just be absolutely clear, looking at 71, taking it by stages, it says if certain things are in play, the matter will be resolved through our disciplinary or capability procedure. So just pausing there, are those words contractual? Do they have contractual force?
We say no, they can't, because the procedures would contain a whole series of matters which aren't contractual, which may be guidance, which may be discursive, which may be contradictory, whatever. We don't accept that this is a wholesale, as it were, picking up and dropping into the contract of employment.
So leave aside the MHPS bit, the words the matter will be resolved, blah, 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 blah.
Yeah.
That bit does not have contractual effect.
It doesn't have contractual effect so as to make E27 part of the contract.
Well, sorry, can I just break it up? Does it have contractual effect at all?
It's in the contract of employment. Just because it's in the contract of employment doesn't mean that it has contractual effect, just as there are lots of terms that can
So-
identify matters that aren't contractually enforced.
So those bits do not have contractual effect.
We don't accept that they do, in the sense that they, as it were, pick up and drop into the employment contract those procedures.
Do you accept that our disciplinary or capability procedures is a reference to E27?
It's a reference, in fact, to disciplinary and capability procedures is in fact a reference to exactly that, E5, which is the trust's. I've not taken you to it as yet, but that's the trust's policy. Can I take you to it now? Supplementary bundle page, core bundle page 205. And this is entitled Disciplinary Policy.
Right.
But as I say, I don't suggest that this is, as it were, a bright line between it can only apply to the disciplinary policy, the disciplinary procedure. E27 has its role. I do accept that.
So I don't think I've understood the difference between E5 and E27. So E5 is dealing with disciplinary.
It deals.
matters, and our current case is not a disciplinary matter, is it? Or is it? Or is that a dispute?
Well, it deals with investigations into concerns in relation to conduct and performance. That's what E27 is concerned with.
But if there are concerns found about conduct and performance, what's going to be the consequence?
That you will be put into E5.
And that means, in a nutshell, to a layperson, what does being put into E5 mean?
It means that you're being put through or subject to a disciplinary procedure.
Right.
So in a case like the present, you first go through E27, and then you, if the outcome is a particular outcome, you then go through E5. Is that right?
Yes. If there's a particular outcome, yeah.
So E5 is where it's disciplinary. That's where the employer has resolved, as it were, to charge you with a breach of contract. And no doubt there can be various outcomes, including ultimately dismissal if it's serious enough.
Yep.
But E27, we haven't got to that stage. We're not in a disciplinary
E5
procedure.
E5 is
Current case.
is when there's an investigator. If I can just put it in very simple terms, there's the case investigator in an MHPS context comes up with a report, and that report has a series of routes open to it. And if in this case, a hypothetical case, it's conduct,
Yeah.
what then happens is that MHPS, say for some trace elements, MHPS is exhausted, and you then go into E5.
The point about MHPS at the sort of national level was to handle questions about capability and conduct without necessarily leading to a disciplinary. Is that right?
Yes, it's a principal driver was that the previous system was heavily quasi-judicial, so you needed
Too many lawyers.
not just lawyers but also adjudications and burden and
Panels.
standard of proof.
Yes.
And so there was a quasi-judicial, not just flavour, but there was a quasi-judicial impetus in it, which was quite different to any other employer in the normal sphere. And the idea was that that needed to be changed, but also what went along with that was a culture of suspension, which those procedures gave rise to huge delays in getting these cases through, which meant that there were doctors who were suspended, excluded for years.
Yes. And so MHPS and E27, which is the Trust's adoption of MHPS, because it doesn't directly apply to the Trust, because it's not a...
Well, it did in 03. It's in two sections. It's in two sections, and I picked this up in my speaking note. Can I just take your lordship to?
Well, then just
I'll stick to the point.
the point we're on is, what does our disciplinary or capability procedures in 17.1 mean? What's it a reference to? Now, the disciplinary procedures, I think you accept, is a reference to E5.
Yes.
Do you accept that our disciplinary or capability procedures is also a reference to E27?
As a hard edge no, we say it's only a reference to E5 if you're being put through a disciplinary or capability procedure. But I'm not going to stand on that too harshly or too much, because plainly, when they're dealing with issues in relation to conduct, competence and behaviour, that is, if you're a doctor, that is being looked at through E27. So I'm
Okay.
But regardless of whether it's incorporated expressly or impliedly, you still have the issues in relation to aptness.
Yes, so I understand that, but that is a second
Mm.
question.
Yes, it is. But in this case, the judge's analysis was very simple, which was it is incorporated because we conceded it,
Mm.
and we didn't.
Did you concede that, in principle, a particular term of E27 could be incorporated?
Exclusion. In principle, we accepted there could be some certain provisions of E27 in relation to Part 2 in respect of exclusion, which has a fundamental importance on the employment relationship. We accepted that, but we didn't accept that E27 was picked up and dropped in. Now, the claimant's case was that MHPS was in fact picked up and dropped in. They didn't pursue that. The claimant's case after that was that it was expressly incorporated. Can I just take your lordship to the list of issues cited in the judgment? Got an eye on the clock. If you look at page 42, paragraph 11. I beg your pardon, it's paragraph 3. Paragraph 3, page 40.
Right, thank you. And which subparagraph are you on?
Well, it's one, is it incorporated into the contract of employment, issue 1? And whether following, and if it is it apt to be given contractual effect in 1.6? Can I just turn my back on? Mr Mitchell reminds me that our concession in relation to parts of it might be incorporated at page 336, which exhausts my bundle. I'll have to use his laptop.
Which bundle?
It's the supplemental
336.
336,
Thank you.
which is the list of issues. 336, which is there was some turbulence experienced in relation to what were the list of issues, but we didn't go there. And at 336, my lord, to answer your point directly, we accept that part of E27 may have contractual effect where conditions for incorporation and enforceability are met.
Yeah.
And the example we gave was in relation to exclusion.
So that's by way of example.
Yes.
So does the critical question in our case become whether paragraph 1.6 of Appendix A of E27
Yes, I agree.
has contractual effect? And that depends on, because otherwise the question whether the whole of the policy, E27, is incorporated may be an abstract one which doesn't actually have to be resolved on this appeal. What is this right? What
Yes.
you're really asking us to say is that paragraph 1.6 is not
Incorporated.
it doesn't have contractual effect,
Yes.
which could be for a number of reasons,
Yes.
or all of these reasons. It's not incorporated, it's not apt to be incorporated, and it doesn't have the meaning which the judge thought it had.
Yes, well, that's it. I hesitate to get drawn into this because, as your lordship has encapsulated, that's what the appeal is about, as I opened it, which is that this is about whether 1.6 has contractual effect and for the reasons which I've already identified.
But you've been drawing in the last 5 minutes or so, you've been, I think, drawing a contrast between, for example, a disciplinary process
Yes.
and the subject matter of this kind of process. But from a doctor's point of view, if their conduct and performance is being investigated, could the sort of negative corollary of that be that they could well find themselves being criticised?
Yes, I accept that.
And
The-
that might not be directly, at least, a disciplinary or dismissal matter, but would you accept that that could be very damaging to the reputation and professional standing of a doctor?
Absolutely. For instance, why, if they're excluded, what the reputational or professional impact might be if they are. I accept that.
But even if they're not excluded, under E27, as I understand it, you have a case investigator who looks at the facts and then makes a report. And at
Yes.
that point, a decision is made as to what to do with the report. And one of the possible outcomes is to go into a disciplinary procedures
Or a capability procedure, yes.
or a capability procedure.
Yes.
This case, our case, is not about capability, but it is about behaviour, it's about conduct, it's about how you behave. And that could lead to an outcome in which, as I understood you to say earlier, you could then tip into E5 and you get
Yes.
a disciplinary outcome.
Absolutely.
And could that lead to dismissal ultimately?
Ultimately it could, yes, in the right circumstances.
So why is that not as critical to a consultant as redundancy pay or other things which could lead to dismissal?
But my lord, that's a different route. We were looking at point 17 in terms of its language. If the route is that this is of such importance to me that it's impliedly under E27, it's impliedly incorporated, then that's a different point. That's the point I raised earlier with Lord Justice Singh in the other case of Byrne, which was about the opportunity of the individual to see correspondence relating to the case. And in that case, the employer accepted it was a contractual right, it was a contractual obligation, but didn't accept it meant what that was being contended on behalf of the doctor in that case. So this is it's slightly unsatisfactory in that what you have is the framework or the policy hanging, and you may get drawn down contractual rights which are enforceable.
So just see if I see if I've got it right. If you take section 2 of E27, which deals with exclusion,
Yes.
you accept that at any rate some of that has contractual effect.
Yes.
But on your case, it doesn't have contractual effect because it's brought in through clause 17.1 of the contract.
Yes.
It has contractual effect because it is implied into the contract.
It's implied because it's apt to be incorporated, and it's of significance in the 5 matters that I drew out a little bit earlier, not least in relation to its general importance to the parties. And of course, suspending somebody, taking them off the tools, taking them off clinical activities, it is of importance to the working relationship because it maintains the working relationship but severs the working relationship, albeit in a temporary way.
So going back to your concession at page 336.
Yes.
D contends that parts of policy E27 may have contractual effect where the conditions for incorporation and enforceability are met. Those conditions for incorporation and enforceability, are they coterminous with aptness? Is that the question? Is it apt to be incorporated?
Well, the two are the same.
They are the same.
They are the same because you can see it certainly.
So when you look at what you say about question issue 2, whether the particular provision, paragraph 1.6, is incorporated, C says it is, D says the provision does not satisfy the conditions for incorporation and enforceability. So that's the aptness question.
It is, yes. But all I was going to say to you, my lord, was that there are some cases in which the parties, especially on a collective level, where the parties have agreed that the term is apt. So the case that's cited by, referenced in the judgment below and Unite the Union, where they agreed that the term was apt to be incorporated, but the court nevertheless decided that it wasn't apt because of the potentially disastrous consequences which could flow from it. But here, you've got to get through the aptness gate before you then get on to the meaning gate.
And the aptness gate is really the Chakrabarty conditions.
Yes.
And in which case, is there any separate point on issue 1? Because your case on issue 1 is, yes, it can be incorporated if it's apt to be incorporated.
But it's not through that. It's not through 1.17.
It doesn't matter how it's there. Well, once it's accepted that if it's apt to be incorporated and sufficient and meets the Chakrabarty conditions, then it's in the contract.
Yeah.
Does it matter how it gets there?
Well, it does, because in a lot of these cases, there are very significant arguments about all aspects of the MHPS policy that is adopted. So if you've got here, which is just, as it were, a clear open gate, that it's all in there on the claimant's case, then you open yourself up to all sorts of challenges which you then have to meet in relation to aptness and meaning and so on and so forth. That's why I'm being cautious about it.
Well, I can understand you being cautious.
And we have to be, because the level of challenge can be quite extraordinary.
What we are concerned with in this case is 1.6.
Yes.
On 1.6, you say it doesn't meet the Chakravarti conditions, it's not apt to be incorporated.
Yeah.
If we decide that question, is it apt to be incorporated, that seems to me to answer both issues 1 and 2 on
Yes.
your case.
But they are opposite sides of the same coin.
So we don't need, is this right? Does it follow? We don't need to decide whether the route to incorporation, if it is apt or an implied term, because you do concede that if it's apt to be incorporated, meets the Chakravarti conditions, then it is incorporated.
Yes, but this has taken more time than it should because of me. We couldn't let this point go though, which was that it was supposedly incorporated because we conceded it. We didn't. Yeah, absolutely didn't. We wouldn't.
Can you just remind me, forgive me for dwelling on this, but in Byrne, and there may be other cases as
We've
well.
got it.
Can I just ask this?
Sorry.
Was that a case where a term in MHPS was incorporated into an individual contract of employment, or has that never been held before?
It was conceded in Byrne that this was a contractual provision because it met all the conditions.
So in terms of MHPS,
It was a term of E27.
right? But
Which was the
reflecting MHPS,
It reflects entirely.
but which it might be said is what's happening in our case as well.
Yeah.
1.6
Exactly.
didn't come out of the blue, as I understand it. It reflects a provision in MHPS.
Yes.
Yeah. So we wouldn't. I mean, I think one of your concerns is that we shouldn't hold that the whole of MHPS is incorporated into every doctor's contract. But that's not the issue before this court. And, as my lord has observed, what we're really concerned about is whether one particular term in E27, clause 1.6, is or is not incorporated into the individual contract of employment.
Lord, yes, that's why we deal in our skeleton argument. The vast majority of it is dealing with aptness meaning. Just tab 19 is Byrne, just so whilst it's fresh in my mind.
Let's look at that. Yes, thank you.
This was a case of a neurosurgeon who was being investigated by a total reference case manager who was not the medical director. It's a point I'll pick up on a little bit later. Was not a medical director, was in fact a manager below board level, I think 2 levels below board level. Because the reference to the High Court decision, I can give your lordships a little bit later. And that was a case in which part of the investigation, the doctor, represented by the Medical Protection Society who appear in this case, who instruct my learned friends in this case, the doctor wanted to see correspondence relating to the investigation. And if I can just take your lordships very briefly to that what was being looked at on page 476 was paragraph 1.6 of the MHS procedure, 1.16.
So which page?
Page 476. And this is in fact sideline.
Yes, thank you.
And Lord Justice Underhill, in parenthesis, identified what the right that was being pursued. And that was the practitioner must be given the opportunity to see any correspondence relating to the case, together with a list of people being case, investigator, and will interview. And the argument being raised somewhat ambitiously in that case was that that gave rise to a whole general disclosure obligation, but also correspondence relating to the case meant that the doctor in that case was entitled to see everything that came across the desk of the case investigator. And the court held that correspondence relating to the case doesn't have either of those two meanings. But the point that I was making a little bit earlier was that the employer in that case had accepted that that was a contractual right, in the sense that there is an essential safeguard there that they should see relevant correspondence, but they didn't accept that that included or could be properly construed as meaning references to either the estate of the documents or all the letters that had come across the desk.
As I read this judgment, that case, the hospital, the trust, accepted that clause 17 of the claimant's contract of employment in that case, which was in similar terms to our clause 17, did, by referring to procedures, refer to E27. And I don't think you do accept that.
No, but my lord, I'm not sure it's a. I'd have to go back to see what counsel dealt. How counsel.
Paragraph 8, Lord Justice Underhill says, it is common ground that the procedures referred to in clause 17 include the policy. And the policy is referred to.
Oh yes,
paragraph 2.
yes, I see that. That's the policy.
That's E27.
Yes, but that's not a concession that E27 was contractually applicable, was contractually enforceable throughout. That's simply an acceptance, as I read it, an acceptance that that's what that was the relevant policy.
I mean, it may be this just wasn't argued, my lord, and you might know better, but superficially it looks as though the provision we see in paragraph 11 is being thought to have contractual effect through clause 17 of the contract of employment that was at issue in that case.
That's a reading of it. I don't accept that that's how the case was framed and argued on the basis of my reading of it.
Can I ask you something else? You reminded us earlier that at a stage in this process, your clients accepted that the investigation should be carried out under E27 and
Yes.
changed the terms of reference.
Yes, to say that.
Why is that not a sufficient answer to what is effectively issue 1? And whether or not it would otherwise have been incorporated, it was agreed that it would be dealt with under E27.
Yes, but that doesn't mean it was accepted that it was a binding contractual obligation to apply. That's part of Malone Friends' cross appeal, which we've got quite a bit to say about. But that's just simply saying we're going to apply a policy that we regard to be relevant doesn't mean that you are thereby accepting that it's contractually enforceable. Because if you did, the chaos that would flow from that would be that there would be an argument every single time that if you apply it, it's therefore contractually binding. If it's contractually binding, you may well have contractually breached it. It's simply saying, here's the policy, we'll follow it. That's all it's saying, which is what was being urged numerous times in correspondence before. It's what the doctors' representatives were urging the trust to do. And the distinction at that stage was that the trust didn't regard it as a matter of conduct or performance. And then they plugged it into a matter of conduct and performance, but also said, we can still treat it as trust and confidence. That's a sidestepping issue which we've dealt with, we're not going to deal with. That's the sort of complex matrix effect that was being dealt with by Miss Y throughout this period.
And just coming back briefly to the provision quoted in paragraph 11 of Byrne,
Yes.
that was accepted to have contractual effect, was it?
Yes.
By whatever route?
Yes.
Yes, I see.
The obvious point being that if you're a doctor, you're under this investigation and matters are being corresponded with, say for instance, with the GMC, with other concerned bodies, you're entitled to see that the employer is playing with a clean and open hand. Can we get away from expressing cooperation and deal then, if I may, with issues of
Aptness.
aptness? Looking at the time, I'm hoping to nearly get this finished
Yes.
by lunchtime. Can I take the court for the first time to our speaking note? And this is genuinely put forward in order to act as a map and compass through what can be at times procedures that are less than clear. Sometimes they're perfectly clear, sometimes they're not. But also less than clear in the sense of who occupies what role and when. There's an awful lot of concurrency or overlapping between roles. And that's why we've attempted to do this so as to assist the court. And what we've also done is cross-reference every reference under E27 to where it may be found under MHPS, even though what you're concerned with is the E27 provision. But of course, as we know in this case, 1.6 is a mirror of what appears in MHPS. So that's what we've attempted to do in relation to the speaking note, and that has, in paragraph 2, I say an important initial point, which is, we've touched upon this earlier in relation to trying to lawyer the process in 2003, and the de-lawyering of the process, or the lawyering of the process, led to huge delays and prolonged suspensions. And that's why in paragraph 2 we highlight there how parts 1 and 2 were brought in, and the instrument by which they were brought in, which were directions on restrictions of practice and exclusion from work. So it not only did that, because that's part 2, but it also introduced part 1. But it's, let's say, an important part, if not the principal part of it, was to bring in a new system in relation to exclusion.
Can I just check the date? In line 2, it says December 2023.
Yes, to be enacted by the 1st of January 04.
Yeah, does that mean 2003?
I beg your pardon? Yes. 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 It's not all retrospective. It's 2002. That's my one again for Mr. Mitchell. And that's an important point. And that I say is part of the concession that we make in relation to exclusion can have a real effect. But also goes to our point in relation to clause 2.14, which I'll come to, which is that the medical director has a chance there to delegate the role to a senior manager in cases where there has been either an immediate or there's going to be a formal exclusion. So in other words, in the most serious of cases, the power to delegate is there. And it is most curious that if in the most serious of cases you can delegate it to a senior manager who isn't a medic, it's very inconsistent, we say, hugely inconsistent with 1.6, only meaning that the medical director has to stay with this case throughout, regardless of what happens. But we'll come to that in a little more detail. And this is the point which I identified at the beginning, which is that foundation trusts were incepted in 04, but they were then deemed to, in fact, treat this as guidance, because their constitutional independence from the NHS means that they have a different structure of governance. Means that they are to treat this as advice rather than to be implemented, which trusts do. But in this case, the trust was an NHS trust, and therefore had to implement 1 and 2, which it did in relation to parts 1 and 2. And then the second part, which was parts 3 to 5, which had to be implemented by the June of 2025. I think it's 5. Yeah, the 1st of June 05, that's called Bundle 147. That then brings in parts 3 to 5, all of which are then sit within E27.
Now, I do have a bit of a concern. You're quite right. You were looking at the clock a moment ago. If we go through the speaking note in this degree of detail,
I'm not going to.
you will be past 1 o'clock already.
Yeah, I'll zip past it. I'm not going to do that. What I want to do is use it in order to lean on certain provisions. which gives the court its
Yeah.
objective compass as
Yes.
to what these proceedings mean. Can I take the court, therefore, to start with the V clause, which is 1.6, and in Appendix A, but invite your lordships to, as it were, keep a finger on that and look at the, as it were, the implementing instrument, which is MHPS, which at part 1 is at page 153. And at 153, under part 1, action when a concern arises, just looking at the subheadings or the titles, introduction, you need to look at that, framework for NHS proceedings. And that's why I took your lordships earlier to the Wandsworth case, which is precisely on that sort of territory, we say, which is that when you're dealing with frameworks for procedures, it's much more likely to be guided than it is to be binding, a binding contractual obligation. And if we then go to 1.6, we've broken this down into 10 parts, but I think we said in the skeleton it was 11. But it is, as it were, a framing document that says internally to the senior members of the trust where responsibilities lie. And it's no more than that, we say. So you've got serious concerns must be registered with the CEO. You've got the CEO must appoint a case manager. The chair of the board must designate a designated board member to be appointed. That designated board member must oversee the case and ensure that momentum is maintained. I'm just breaking it down. Concerns must be investigated quickly and appropriately. A clear audit route must be established. The medical director will work with the HR director to decide appropriate courses of action. Key clause here, the medical director will act as case manager in cases involving clinical directors and consultants, but the managing director may delegate the case manager role to a senior manager to oversee the case on his behalf in other cases. And the managing director, so the medical director, I beg your pardon, is responsible for appointing CI. So there is a condensed paragraph there, which we say plainly is framework, plainly is guidance, and is plainly just simply identifying roles. Not on the claimant's case, the doctor's case, and not on the judge's interpretation, that this somehow establishes a contractual obligation on the managing director, and only the managing director, unless there are exceptions, to act as case manager and respective consultant.
And just taking out of your course briefly, this is a document that had been agreed with the unions.
Yes, it had the JNC, the joint negotiating.
Yes.
And well, no, can I just go back on that? Can I just? I'm not sure it was, because it was issued in the December of 03 and it was implemented and had to be implemented in the January 04. So I'd have to check that to see whether there was input from collective consultation and negotiation about it. It might be that this is simply a drawdown, and it is, we say. And that's why this case has national implications, because that's what everybody else did effectively in the timescale, that you drew down on MHPS in your own policy. So can I check that, my lord, over fast approaching lunch?
Sorry, but we drew down, meaning every NHS body would draw it down.
Well, I don't know if every NHS body would draw it down, but that's we say the common sense implication. If if the Secretary of State tells you in the
Yeah.
December 03, this is to be come in the January of 04, this is a policy, you've got one of a number of options. The most obvious are you either just cut and paste it and put it into your procedure.
Yeah, don't worry then. So not sure whether this was agreed with the union. At any rate, would you accept that the bit that says that the medical director will act as a case manager in cases involving clinical directors and consultants could be expected to be important in the eyes of consultants?
On one level, yes, but on a more important level, no. And by that I mean, which is that you've got to look at what this document is doing. This is not establishing rights for consultants. This is establishing roles based on the framework and procedure. So it might give the consultant reading it an expectation that it will be the medical director. And indeed, part of our point here is that the flexibility of this system is that it likely might be, or likely would be, and on the evidence, very often medical directors do act as case managers. But what this doesn't do is provide for an inflexible contractual right, and therefore an inflexible contractual obligation on trusts to only have the managing director, I keep saying this, the MD, to only have the MD involved when it's dealing with consultants and above.
Yeah.
So you can get that, but it's not nothing of any importance, we say. And can I just deal with that point head on in relation to 1.6? Because if it was saying that, it's drawing a very odd distinction between the vast majority of doctors who sit below that level. In other words, residents or trainee or junior doctors.
Sorry, why is that odd?
Well, it's odd because you could have all levels of seniority in relation to doctors, but just because they're not a consultant, somehow, I'm just facing the claimant's case here, somehow you have the right only to have the medical director as your case manager. It's a very odd line that can be drawn because you have very senior doctors who are on the verge of becoming consultants, depending on the specialism. If you're a surgeon, for instance, and specialist sub-surgery matters such as neurosurgery. So it's an odd arbitrary. If the claimant's case is right, it's a very arbitrary line that is being drawn between only an MD can act for a consultant and above, whereas a senior manager doesn't have to be a clinical manager. A senior manager can be involved in relation to other grades. And that's my point, which I say, which is that goes to, this is an identification of roles, not a cast iron, as it were, proclamation of what those roles actually are. It builds in the flexibility. So the case manager can be the MD, but the MD can decide to give it to somebody else, as long as they're suitable, including a senior manager, which applies to the the balance of the doctors.
Can I just ask you about the language?
Yes.
I mean, this is the same language as we have in what we're looking at it in MHPS.
It's a
the
drop
same.
down.
It's the same.
Yes.
May delegate this role to a senior manager to oversee the case on his or her behalf in other cases. What does "in other cases" mean?
We take that to mean cases that aren't involving consultants or above. I think everybody else takes
Yes.
that view. That's my point about that's a very odd arbitrary line. If this is a point of
Yes, but-
importance.
Well, I understand that, but that's what the sentence says. It draws a distinction
Yes, it does.
between, on the one hand, clinical directors and consultants, and on the other hand, other cases.
Yeah.
Now, you may say it's an odd place to draw a line, or that it's odd to have a line at all, but as a matter of language, it does draw the line.
Yes,
in
it
that
does.
Point.
Yes, but our point is that this isn't contractual. This isn't contractual.
No, well, let's leave aside whether it's contractual or not. Suppose it's just guidance.
Yes.
To the NHS Trust or the NHS Foundation Trust. The guidance draws the line between, it puts people into two boxes. Either you're in the box marked clinical directors and consultants, or you're in the box marked other cases. Now, I understand the submission that there can be people who are very near the line and it's odd to have a line drawn in that position. But given that that's what the document appears to do, well, does do, it distinguishes between these two different boxes. Does it, I mean, how can we sitting here say, well, that's an odd place to draw the line, because that's where the line is drawn?
But it's a very fuzzy, non-binding line, is what we say. Yes, you draw the line there, but that in no way stops you from the medical director, for instance, acting as a case manager for sub-consultants.
Well, it doesn't, that's clear, because it says it may delegate this role. It clearly does, it's not obliged to delegate
Exactly.
the role. So if it was a senior doctor who was very near to being a consultant but not in fact a consultant, the medical director could clearly say, I'm going to keep this case to myself.
Yes, that's the flexibility that's built into it.
But the problem as a matter of language that I'm having is that if you have a clause which says you've got two boxes and with one box you may delegate, as a matter of just ordinary understanding of the meaning of words, you would take that to mean, but you can't delegate in this box. That's the problem I'm having. And you say that it nevertheless does mean that you can delegate in all cases.
It has to, in my respectful submission, in order to give this common sense and workability. And can I just take your lordship to where we say that becomes clear? And I wasn't going to deal with this. I just wanted to, because your Lord Justice Nugee is concerned about this point, that you've got to look at the document as a whole. So if I take your lordship to page 243, sorry, 241, which deals with restriction of practice and exclusion from work in section 2.
We're now actually not in NHPS, we're in E27.
We're just in E27, yeah.
Yes. At the top it seems to say C27, isn't it?
No,
It is in fact,
I've never had an explanation.
it is in fact E27, yes.
Why C becomes E. I've never had it, and I doubt I ever will. So this is under exclusion, and 243, 242, the exclusion process, roles of officers in the exclusion process. You've got, and I'll come to this in lightning way, I hope, after lunch. But 2.14, so you've got a near replication of what's in 1.6, but without it being the jealous preserve of the consultant or clinical director. So you've got the express power to delegate if you're taking the most serious step that there is, which is exclusion.
If I've understood it correctly, if the result of the investigation is that the investigator recommends to the case manager that there be exclusion, the authority to exclude still rests with the medical director. Isn't that what 2.13 says?
Well, the medical director or the CEO under this policy 2.13 have the power to exclude. There are two types of exclusion. One is immediate, and that is dealt with at 2.16, and the other is more what's known as formal exclusion. That's over the page at 244, paragraph 2.17. This 2.14, which is identifying the roles and the power of delegation, is, we say, helpful interpretive guidance. That if 1.6 says you will act as the case manager and respective consultants, that's confirmed by 2.14, we say, because in the most serious of steps where you exclude, you don't have to take it as the case manager if you're the medical director, and you can delegate it to a senior colleague. It doesn't have to be a medical cue.
Could it be a point that cuts both ways, though? Because the fact that that's expressly set out in 2.14, could that be an indicator that that's not what 1.6 means?
Sorry, Lord, I'm being a bit, I got distracted. Can you
Well,
pass
the
me that
fact
again?
that there's express reference to the power to delegate
Yes.
in 2.14,
Yes.
could that be an indicator that when the draftsperson of this document, whatever its effect is, let's forget it, whether it has contractual effect or not, just as a matter of meaning, what does it mean? Could it be that the express provision about delegation in 2.14 is some indicator that the draftsperson did not intend that in 1.6, because they could have said, you accept that? That's a point against you.
Well, no, sorry, I've told you, sorry, I'm being a bit slow. Can we just go back? The position in relation to 2.14 is either that's a bespoke provision which sits on its own, or it is to be read as a whole in relation to 1.6. And our point is that when you are coming to specific exercises of power, so that specific contractual provisions, such as exclusion, the, as it were, the ironclad condition doesn't exist. And it's very very curious that if 1.6 means that, why in the most serious of cases 2.14 takes away that ironclad.
Now,
obligation. And the Lord-
We are at 1 o'clock. Can I
Yeah.
just take stock for a moment? Because I'm afraid we cannot overrun today. It's not possible. Now, I'm hopeful that Mr Sutton will say that because we will have been through a lot of stuff this morning, he doesn't need to be quite as long. But I'd like just to work out how the timings do work. Taking it by stages, Mr Sutton, were Mr Gorton and Mr Mitchell in a position to sit down by 2:30, would that give you enough time?
My lord, we'll cut our cloth.
Good. Mr Gorton and indeed Mr Mitchell, half an hour come 2 o'clock, sit down by 2:30.
Yes, well, I might finish at 2:29.
That includes Mr Mitchell.
That's the joke.
I see.
Give it a minute. I'll try and get mine done in. If you sit at 2, I'll
Yes.
try and get mine done in 20.
Yes,
Gives Mr Mitchell
10 minutes.
10 minutes on the stage, and then we'll sit down. Then Mr Sutton, who's a tailor for these purposes, and if I need to respond to come back, I'll consider whether I just put something in writing.
I'm not sure about that, but in practice, experience teaches us that it's a rare case where much needs to be said in reply.
Yeah.
In reality, the ground will normally have been covered, or
I get
bar a
that.
few points. Mr Sutton.
I wonder if you'd kindly indicate when you propose to rise, just so Miss Newbegan and I can make sure that we accommodate that.
I suspect, I mean, normally we would rise at 4:15. I think it could be stretched to 4:30, could it, or not?
Yes, at the outside.
At the outside, it could be stretched to 4:30, but definitely not beyond 4:30.
All rise in favour.